Hi, I'm Scott Wyman, a training technology coordinator at Central Texas College, and I'll be your guide through this session. This session, we're going to talk about supervisor equal employment opportunity sexual harassment prevention. This is part 2. So this is the preventing and reporting of sexual harassment and sexual misconduct. All right, we're going to start with definitions because definitions, well, it's a good way to start. That way you know exactly what we're going to be talking about. So this is the definition of sexual harassment, unlawful sexual harassment. I don't know that there is such a thing as lawful sexual harassment, but it's pretty simple. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating or hostile work environment. Got that? Pretty easy, right? Let's make it simple. Number one, it must be unwelcome. Okay, unwelcome. So how do we know that any particular given behavior is unwelcome? Well, if you think back to part 1, if the other person didn't ask for it, then it's unwelcome. You can also judge normally by a person's reactions. If you do something or say something and that person objects, they'll usually make a face, or they'll shy away, or they'll make a comment, or some subtle indication to you that what you just did was unwelcome. So there are 2 types of sexual harassment. The first one is what we call quid pro quo. Quid pro quo is direct harassment. It means this for that, right? Quid pro quo is Latin. It means this for that. So this for that specifically benefits the harasser. So when a specific benefit promised or withheld to coerce gender-based favors. Okay, if a sexual favor in return for something is going to enhance the other person's job, pay, or career. As supervisors, we need to understand that there is a strict liability for CTCD for acts of harassing supervisors or managers, or if it's happening within your work area. Because here comes that if the employer knew or should have known about the conduct and failed to take immediate action to investigate and take remedial actions, then there's going to be trouble. And it's not just for the college. It can be the harasser. The harasser can face individual liability, including punitive damages for harassment, assault, battery, false imprisonment, infliction of emotional distress, and they could also face criminal charges. So again, we as supervisors, thinking back to Policy 220, it's our job to provide our employees a work environment that's free from harassment and discrimination. So we got to keep an eye on things. The other type of sexual harassment is hostile work environment. So for this one, there doesn't have to be any formal request for a sexual favor. If you look at the definition, repeated unwelcome conduct based on sex or gender that is so severe and pervasive as to alter the terms and conditions of the complainant's employment and create an abusive working environment. So again, you'll see it here. It says repeated unwelcome. You do it once and they object, you don't do it again. Ideally, you don't do it the first time. Because who determines whether or not any given behavior is of a sexual nature? Like I said, it doesn't have to be sexual. It just has to be based on sex or gender. And that covers a lot of categories, a lot of territory for that. So we need to be extra careful in our words and actions. And we also need to be very aware of those who work for us, of their words and their actions. So unlawful harassment, we talked about this one at the beginning. But for this one, you need to understand that petty slights, annoyances, and isolated incidents Again, a single isolated incident does not make unlawful harassment. Unless, of course, they're very serious or extremely serious. If they are of a sexual nature, that puts them into that serious category. And if there's touching or other assorted actions, then that could take it into the extremely serious category. But just the teasing about your hair color, about you put mustard on your French fries. That's just petty annoyances. Okay, that kind of harassment would not rise to the level of being offensive. It's still unreasonable for the workplace because that's not how we treat coworkers. So again, watch our words, watch the words of those who work for us. Because offensive conduct could include, but is not limited to, offensive jokes, slurs, epithets, or name calling, physical assaults or threats, intimidation, ridicule or mockery, insults or put downs, offensive jokes or pictures, and interference with work performance. And again, it goes back to the person who's being harassed. How does that behavior impact them? Because what they look at is they'll get the intent versus impact. Your intent might simply to have been to compliment that person, but you may have worded it in a way that the other person found it offensive. And again, it doesn't matter what your intention; it's how they perceive it. They're how it impacts them. Okay, intent versus impact. Impact outweighs intent. So the harasser can be the victim's supervisor, a supervisor in another area, an agent of the employer, a coworker, or a non-employee. It could be anybody. And the victim doesn't have to be the person who is harassed. It could be, as was mentioned in part one of this, it can be anyone who was affected by the offensive conduct. So anybody who sees it, anybody who overhears it, if they believe that that's impacting their work environment, then they can file a complaint. So prevention is the best tool to eliminate harassment in the workplace. So we as supervisors, again, make sure things are going the way they're supposed to. Oversee what's happening. Pay attention to your people and what they're doing or what they're saying. And don't be afraid to intervene if necessary. It's part of our job as supervisors. So the impact of sexual harassment. Did you know that every 68 seconds someone in the United States is being sexually harassed? So that means up until the time we started this until now, 6 people have been sexually harassed, give or take. Me and math don't get along. But if you've never been the victim of sexual harassment or sexual assault, you just have no idea what it's like. You don't know what kind of mental anguish these folks go through after an incident like this occurs. If you have been the victim, I'm sorry. Nobody should have to put up with that. So what is CTC's policy on sexual harassment? That's very easy. Zero tolerance. Although isolated incidents of offensive conduct of a sexual nature may not be enough to create a liability, CTCD does not allow for any potentially offensive conduct of a sexual nature. Again, as supervisors, watch your words. Watch and listen to the folks who work for you. If they step over that line, you got to bring them back. Because remember, this policy applies equally to offensive conduct based on race, age, ethnicity, national origin, or any other protected category under state or federal law. Right? Sexual harassment falls under one of those categories that we discussed in part 1. Can you guess which one? Sex. Very good. All right. I mentioned this earlier, that the behavior doesn't have to be based on sex, right? There doesn't have to be a romantic attraction. It doesn't have to be a sexual act. And the harasser can be the same sex or gender as the victim. Same-sex sexual harassment happens all the time. Don't think it doesn't. Females are harassed by females. Males are harassed by males. And the complainant, as was mentioned earlier, does not have to be the direct target of the harassment. They only need to have some working location as the harasser and the victim and oversees or overhears the harassment. Third party, okay? Who determines whether or not the behavior is severe or pervasive? Well, to be honest with you, the person who's being harassed or the person who was offended. The courts have stated that Title VII is not a general civility code, right? You can't go saying, hey, that's a violation of Title VII every time somebody does something wrong. And this brings us back again to an isolated or single incident of harassment, even of sexual harassment, unless quite severe, will not create an abusive environment. Will it create a hostile environment? It could very well create a hostile environment. The simple telling of a sexual joke can make some people very, very uncomfortable. So that's the kind of behavior we need to pay attention for. Is it sufficiently severe and pervasive? It has altered the terms and conditions of employment. Again, who determines whether or not the conditions of their employment has been violated? The person who was harassed or filed the complaint. Okay. So listen, just little things like women can't figure these things out, or leave it to a man. They'll screw anything up, right? Not the kind of behavior we want to see at work. So you can put it to a legal test in your mind before it rises to the level of ending up in a court. Number one, was the conduct unwelcome? And again, did the other person ask for it? If the other person didn't ask for it, then it's unwelcome, plain and simple. Number two, was it because of gender or sex? Simply ask the question, would you have done or said the same thing to a person of the opposite sex? Not the opposite sex from you, but the opposite sex from the person who was harassed. And number three, would a reasonable person of the same gender as the victim, considering all of the circumstances, find the conduct sufficiently severe or pervasive to objectively alter the conditions of employment? And what conditions are we talking about? We're talking about that work environment that's free from harassment and discrimination. Once those conditions are altered, then you're in trouble. So we got to keep an eye on things. All right, so there are three different types of sexual harassment. There's verbal sexual harassment, there's visual sexual harassment, and then there's physical sexual harassment. So you kind of look at these as stepping stones, right? Verbal is probably the lowest form. Visual is the next higher level of sexual harassment. And then physical, if it gets to the physical point, it's just bad. Okay, that's when it hits that extremely severe category. So verbal harassment, what are we talking about with verbal harassment? Well, off-color or dirty jokes, sexual banter or horseplay, unwelcome remarks about a person's body or how they're dressed, or maybe just their physical appearance. One person's compliment could be another person's sexual harassment. So again, you have to be extra careful with these kinds of things. Name calling and profanity could be considered verbal harassment. Questions or comments about sexual practices, fantasies, or dreams. Patronizing terms or remarks. Propositions or requests for sexual favors, dates, or meetings. We don't prohibit the dating of coworkers, only if it's within the chain of command. We don't allow that. There's a policy for that. And we're also talking about inappropriate telephone, email, or voicemail messages. So those are some verbal examples. Visual harassment, staring, oogling, leering at somebody. Okay, or giving some sort of sexual gestures. letters, notes, or emails that carry gender-based, unwanted, explicit, or demeaning messages or pictures. The display of sexually suggestive photos, calendars, cartoons, drawings, or screensavers in the work environment. Pictures if they depict an individual who is nude or partially clothed, not in the workplace. If they're clothed in a manner that's not suited for customarily accepted routine work in and around the workplace. Okay, having a picture of a guy in a Speedo or a woman in a bikini hanging on your office wall. No, 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 no. Or if the person in the picture is posed for the obvious display of the body or body parts. Okay, so they could be fully clothed, but depending on their pose, could be considered inappropriate and possibly even visual sexual harassment. Then comes the physical harassment. Again, this is a top tier when it comes to this. Unwelcome gifts, sleepwear, or perfume. And we've had this happen here at CTC. We don't put this in here just for the heck of it. Impeding or blocking a person's normal movement. In other words, if you know that that person has to walk down the hall to get where they're going, and you step in front of them and block their path to where the only way to get past you is to brush up against you or something, that's physical sexual harassment. Unhooking, unzipping, or lifting of a person's clothing, kissing, fondling, grabbing, or caressing a person. And then in its most severe form, sexual assault, battery, or rape. Okay. All right. Let's take a look at Title IX. Y'all know what Title IX is. I'm sure you've heard it before. But specifically, we're talking about Title IX of the Education Amendments of 1972. What Title IX does is it prohibits sex discrimination, including pregnancy, sexual orientation, and gender identity in any education program or activity that receives federal financial assistance. And guess what? We're one of those. Okay, we receive federal financial assistance. So that means we have to make sure that all of our students get the same equal opportunity in the classroom as everybody else. And this comes from the U.S. Department of Education's Office for Civil Rights. They're the ones that enforce Title IX of the Education Amendments Act. So what is sexual assault? Sexual assault is defined as illegal or non-consensual sexual contact with another person, including but not limited to rape, fondling, incest, or statutory rape. Our policy that we have that covers sexual misconduct is HR Policy 221. And according to this policy, consent can never be implied. It must be an ongoing thing throughout a sexual contact. If at any point in time, either one of the two parties involved can no longer give consent, then at that point, if the behavior continues, it becomes sexual assault. So the reporting process for sexual assault. If a victim comes to you, number one, first and foremost, get them to a safe place, okay? Contact campus police, and they'll make sure that the person gets the necessary medical attention. CTC employees are required to report all incidents related to sexual misconduct. So again, as supervisors, we need to keep our ears open, keep our eyes open, and be aware of the happenings within our department. Your point of contact for Title IX actions. CTCD employees and contractors who have reason to know of, not witness, but know of, or suspect sexual misconduct has occurred on CTC campuses or sponsored events are required. Got that? You're required to promptly report all incidents related to sexual misconduct to any of the following individuals. Our Title IX coordinator is the Director of Risk Management, and there's the director's phone number. The campus police and their phone number. You can also contact local police depending on where you are and where it happened. You should also contact the Dean of Student Success and Persistence. And then, of course, the Chief Human Resource Officer. So any one of those folks you can report sexual misconduct to. Employees receiving a report or complaint or violation of this policy are required to immediately report to the CTCD Title IX coordinator and or the Chief Human Resource Officer, kind of like what we just said in the previous slide. The Title IX coordinator will report violations of this policy to the CTC Police Department as necessary. So it's not just a local thing to where, we're going to investigate and smack the person on the wrist. This is going to be serious business. When it comes to confidentiality and the sexual harassment, sexual assault investigations, understand and make sure your folks understand that CTCD cannot guarantee confidentiality of any report of sexual misconduct and must investigate all reports. If a victim chooses to make a disclosure to CTCD personnel, the victim will be informed in writing by the Title IX coordinator to ensure that the informed expectations concerning privacy and confidentiality are met. CTCD will, however, treat all reports and information relating to a violation of this policy with the utmost sensitivity and protect the information to the extent possible by law. And as supervisors, again, we need to remember not to retaliate. Y'all remember retaliation from part 1, right? Yeah. Okay, I thought so. So again, retaliation is any attempt to penalize or take adverse actions against an individual for reporting and or participating in a complaint investigation, legal and or administrative proceedings, including litigation regarding allegations of sexual misconduct, is strictly prohibited. Violation of this anti-retaliation provision may lead to discipline up to and including termination or expulsion if it was a student. All right, this is that policy I alluded to earlier when I talked about having romantic relations with coworkers. Policy 116, HR Policy 116 covers consensual relationships. And like I said, coworker to coworker, not a problem. Not prohibited, not forbidden, not encouraged, but not prohibited, not forbidden. However, if that relationship is between a supervisor and a subordinate, or between a faculty member and a student, then those two must be removed from each other's chain of command. Student will be moved to a different class, employee will be moved to a different supervisor. The obligation of managers and supervisors when it comes to harassment, again, pretty simple. We are to review the policy with our staff on an annual basis. Remember that form I showed you in part 1, so that you can let me know that you've done your annual review. Okay. And again, make sure all your folks complete their EEO training because it is, which you probably already know, it is on the evaluation. And if the training is not current come evaluation time, then they must receive a needs improvement and go on a performance improvement plan at that time. And of course, monitor your work area to ensure that Policy 220 and Policy 221 are observed. Intervene to stop conduct that is questionable or that violates the policy. Like I said, it doesn't have to necessarily create or reach that level of unlawful harassment or sexual harassment. If you see that inappropriate behavior going on, one inappropriate behavior may lead to more inappropriate behaviors. So it's best to stop it at the beginning. Don't let it go any farther. And then promptly notify HR of any violations of policy 220 or 221. All right, we have a couple case examples. Now these aren't by no means the be all get all winning cases like they were back in the day. But when it comes to reporting sexual harassment, remember that if the employer knew or should have known, right? Well, for this one, we're talking about the Baker McKenzie complaint. Baker McKenzie was, and probably still is, a huge law firm, worldwide law firm. And Sheila Weeks was hired by Baker McKenzie, and she worked for her supervisor at the time, Mr. Greenstein. She only worked for him for 25 days. Within those 25 days, she was groped and subjected to rude and inappropriate comments for the workplace. She went to HR. HR took her complaint and then filed that information in her personnel record, not the offender's, because the offender was one of the company's big money makers. So they didn't want to do anything to tarnish his record. So in that case, the employer knew what was going on and they failed to take action. After Ms. Weeks quit, she filed the complaint with the EEOC. I don't remember how many millions of dollars she got out of that, but it was a lot. It would be enough for me to retire on. So again, just pay attention to what's going on. Be observant of what your people are doing and what they're saying. Again, retaliation. Boy, I can't emphasize this retaliation thing enough. Because remember, it's the number one reason people file complaints at the EEOC, right? Yes. So again, what is retaliation? Well, it doesn't have to necessarily be negative personnel action. It could just be any negative action against the person, such as unwarranted discipline. You know, before the complaint was filed, you didn't nitpick on every little thing they did, but now all of a sudden, everything they do is wrong. That's unwarranted discipline. Ostracism by coworkers or the supervisor. You don't start ignoring somebody, leaving them out of the group because they filed a complaint of harassment. If the complaint's against you, the supervisor, you got nothing to worry about as long as you didn't do anything wrong. If you did do something wrong, well, now you got something to worry about. We don't want to see any involuntary transfers or change of work assignments. We're going to see another example of something like that here coming up very soon. But things just as simple as refusing to discuss work-related matters with that person anymore. Or maybe the continued or increased harassing behaviors. Just don't. Okay? Just don't. Treat everybody with the same respect and dignity that you expect to be treated. Just because you're the supervisor doesn't mean you're any better than them. Okay? All right, so here's the other big one. And this is the Burlington Northern Railroad versus Sheila White. I may be wrong about Miss Weeks' first name. Maybe I'm getting Sheila White and Miss Weeks confused. So don't hold me to Miss Weeks' first name being Sheila. All right. But this one, Sheila White. What happened with this one is that a new standard for what's considered to be retaliation was set. Again, not a big outcome money-wise, although there was some money exchanged. But it wasn't a huge huge amount, and that wasn't the idea. What happened with Sheila White, as she worked for Burlington Northern Railroad, she was a forklift operator at one of their rail yards. She was sexually harassed at work. So she reported it to HR. HR came back and took action against the supervisor. The supervisor then put Sheila White on unpaid leave. Okay, unpaid leave. The supervisor had no authority to do that. So when HR found out what had happened, they immediately called Sheila White back to work, gave her all the back pay and everything that she missed. But when it came to getting back into the forklift where she worked before, somebody else had already been put into that position, so they just assigned Miss Weeks to do other tasks within her purview in the rail yard. She filed a complaint of retaliation because amongst the rail yard workers, the forklift operator is considered to be a position of higher prestige. You're not just the manual labor working the yard. You're driving a forklift. You're somebody. So when they didn't put her back in the job that she was doing when she was put on unpaid leave, that's considered retaliation. Think about that. Think about that. So the bottom line for retaliation is easy. Don't do it. And don't let people in your work center do it. Don't retaliate against an employee for making a claim of sexual harassment or for them filing charges of discrimination or sexual harassment. Don't retaliate for a person testifying, assisting, or participating in any investigation or hearing regarding harassment. Remember, CTCD and its individuals committing retaliation can be held liable for their acts of retaliation. Individuals will face discipline for acts of retaliation up to and including termination of employment. So how do we know when an investigation is necessary? Somebody comes to you and files a complaint, I was harassed, whatever the case may be. How do you know when an investigation is necessary? Well, I can sum that up with one word. Always. All allegations of sexual harassment, discrimination must be investigated. If you just push it off to the side and then HR finds out later on that you knew, well, there's that knew or should have known thing, right? I'll leave it at that. Use your imagination. But remember, the liability attaches to CTCD if it knew or had a reason to know, but failed to investigate a complaint or allegation. Because if you knew, well, then HR should have known. If you're unsure of the nature of an allegation, call HR. Okay, call HR. Oops, I'm blocking words. There we go. Yeah, call HR. The availability of a complaint procedure and prompt investigation is not an absolute defense. Okay, just because you reported it doesn't mean you're not guilty. However, failure to provide and inform employees of complaint procedures and failure to investigate will be held against the employer. And it is who's the supervisor that represents the employer? We are, okay? All right. So retaliation, folks, big. Okay, don't let it happen. Take all allegations as if they were true. It's not up to you to decide which ones are true, which ones are made up. That's what the investigation process is for. HR will take care of that. You find out if somebody's been harassed or discriminated against, you call HR. So what triggers that obligation to investigate? Well, any written or verbal complaints to a supervisor, personnel, or foreman from a victim. Any person in a supervisory position, if somebody comes to them and says, hey, I was harassed or discriminated against, that triggers the obligation to investigate. You're going to take that information, you're going to call HR. If you get a complaint from a witness of harassment, hey boss, I wasn't harassed, but let me tell you what I saw. Don't blow that off because they weren't offended and they're not filing a complaint. They're just telling you that something happened. What are you going to do with that information? Exactly. You're going to call HR. We've even known HR to investigate anonymous complaints, even as from victims who asked not to be identified. So never promise to keep complaints of harassment a secret. You're just looking for trouble, because eventually it's going to leak. Somebody's going to know, and they're going to tell HR. And when HR finds out that you knew but didn't say anything, not good. Not good. All right. So we're going to follow up on any information that could arguably alert. You should immediately follow up on any information that could arguably alert CTCD to inappropriate conduct. Again, it doesn't have to be straight into sexual harassment or sexual assault. If it's inappropriate for the workplace, and come on, we're supervisors. We know what's appropriate and what's inappropriate for the workplace. If you think something that's inappropriate was done or said, address that situation right now. Even complaints of past harassment must be investigated. Remember that time frame, 180 days is set out by Title VII of the Civil Rights Act of 1964. The EEOC extends that to 300 days. All right. And then if it's a continuing violation, well, then that time limit is usually not an issue, because it goes from the most recent issue. As supervisors, we should have an open door and an open mind policy. We need to listen for clues and complaints that raise a red flag. We need to encourage reporting of inappropriate conduct. Again, not necessarily stuff that's offensive, because a lot of people do things that I don't find are offensive, but I know it's inappropriate for the workplace. That's how we need to start thinking about this stuff. We need to ensure safety and proper work environment for our employees, because complainants may not want to come forward. They may not be comfortable reporting or complaining about harassing behaviors or inappropriate behaviors. So reassure your employees that they can come to you without supervision. Reassure your employees that they can come to you without fear of retaliation. And if they're not comfortable coming to you, make sure that you won't be offended if they go over your head to your supervisor, or if they go straight to HR. Let them know that, because a lot of times that's what they're afraid of, some sort of retaliation. Okay. And make sure you have HR numbers displayed in your work area someplace. It's always a good thing to have. If not, just make sure that your employees know where to find the numbers for HR. Because the law requires that we take prompt remedial action reasonably calculated to end harassment. The law provides affirmative defense for employers when it has provided steps to prevent and promptly correct harassment, and the employee fails to take advantage of those reporting avenues and corrective measures. In other words, we're here, we're going to help. If the employee doesn't do anything to put that process in motion, then there's not much we can do. But again, you have to remember that knew or should have known thing. Oh, mercy. Yeah, ears open, eyes open. So for some precautionary measures, be objective and don't promise anything. Don't make promises you can't keep. Be consistent in your disciplinary measures across the board with all your employees. Not saying every employee gets the same discipline, but they should get the same discipline based on what they did wrong. Document discussions with your employees thoroughly. We need names, dates, etc., and have the complainant review and sign the document for accuracy. This is if they're filing a complaint, right? And keep the complainant informed. Again, remember that confidentiality thing. We're going to do our best to keep things confidential, but you also have to remember that the complainant does not have that legal need to know everything that's going on. But if they come up and ask you, hey, what's the status of my complaint? Your best response is, let me check with HR and I'll get back with you. You check with HR and then you get back with them. They have to know that we're actively involved in what's happening to them. Call HR to ensure prompt and confidential investigations. Again, remember that HR maintains the entire file on complaints and investigations. You shouldn't keep any of that in your desk. Once the investigation is complete, HR is going to assess the facts and evidence. They'll determine if the complaint is substantiated or not. They'll implement any effective remedy, and they will determine if disciplinary action is warranted based on CTCD policy and past practices as well as the law. They will meet with the complainants and the complainant and the accused separately to communicate the conclusion that was reached. We're going to stress confidentiality of investigation and results. And then we're going to check in with the complainant on a regular basis to make sure that things are going the way they should be going and the harassment or discrimination has ended. And we're going to ensure that all parties know that retaliation will not be tolerated. You should already know that by now, right? Communicate that to your folks. And here are your points of contact should you need. For staff issues, contact our Chief Human Resource Officer or the EEO coordinator. For faculty, contact your respective dean. And for students, contact the Director of Student Life. And that, my friends, brings me to the end. All right, so if you have any questions, you should have my phone number and email address from part 1. So I'm not gonna dirty up the screen with it again. But don't be afraid. Don't be afraid to ask me if you've got questions. So don't hang up yet. Don't hang up yet because, well, here comes the most important part of this training, the completion form. Okay, so you take the first 4 characters you got at the end of part 1, and you take these 4 characters from part 2. So again, case sensitive on this. So the last 4 characters of the passkey for the completion form, 2, a lowercase j, an uppercase F7. So the number 2, lowercase j, capital F, and the number 7. Again, combine these, put the first 4 and then the second 4, make an 8-character passkey to submit your completion form. Look for this Supervisor EEO completion form 1.2. I believe it's still 1.2, but Supervisor EEO training completion form. That's the one you want to look for. All right. Cool. Well, I appreciate you being here. Thanks for your time, your patience. Again, call me if you have any questions. Stay safe, stay healthy, and stay happy. We'll talk to you later.